Now we've got some. I know we've got some folks attending remotely, or at least participating. With the change of the rules, votes are not permitted unless you're here in the room. Even people who are attending remotely from upstairs can't vote unless you're here. I learned that from participating in a meeting a week ago from upstairs, and couldn't vote. So I think we've got a quorum, though, in the room. Mr. Secretary, would you please call the roll?
Senator Berg. Present. Senator Kerr. Senator Neal. Senator Schickel. Present. Senator Schroeder. President Stivers. Senator Turner. Senator West. Senator Wheeler. Senator Carroll.
Remote from my district.
Chairman Westerfield.
Here, seeing that we have a quorum, we are authorized to do business. Again, welcome to the fourth meeting of the Senate Standing Committee on Judiciary. I've got a short agenda, and we're going to go out of order. I know you're all stunned by that. I'm going to take up the first bill, and I'm going to carry it on behalf of Senator Carpenter, who could not make it quite in time this morning. He's got obligations that are keeping him from getting here just in time for the committee meeting. But we had talked about this beforehand. It's a pretty straightforward bill, so I'm going to carry it for him here in the committee. And this is Senate Bill 101 for members who haven't seen it or taken a look at it. It's very straightforward, and it simply prohibits the taking of photographs by first responders outside of their official capacity as first responders. They aren't to take photos and share photos outside of their official roles and capacities. Are there any questions about the bill?
Mr. Chair.
Senator Schroeder got a question.
Thank
you.
We had this last session, correct?
I actually don't remember, Senator.
Yes.
I thought
I'm getting affirmatives from others.
Okay, thank you.
I have a motion from Senator Turner. Was there a second? Senator Wheeler. Any further questions on the? Yes, Senator Schickel.
Thank you, Mr. Chairman. I just want to, well, if I'm not allowed to state anymore.
Do you have a question?
No, I don't.
All right. Well, we've got.
I'll do it when I vote.
Thank you very much. I will. You have my permission, standing permission, to explain your votes. Thank you for abiding by the new rule. All right. We have a motion and a second. Seeing no further questions, anyone? Mr. Secretary, please call the roll.
Senator Berg.
Aye.
Senator Carroll. Senator Kerr. Senator Neal. Senator Schickel.
Aye, and I'd like to explain my vote.
Yes, sir.
Thank you. This bill maybe appears to be minor to some people, but I think it's a great bill, and it really has a lot of practical application. I know over the years there have been, I know of 2 or 3 instances where this has happened, and it's been hurtful, and it's caused a lot of problems to people who were already in very unfortunate circumstances. So I want to thank the sponsor and for doing this.
Senator Schroeder.
Aye.
President Stivers.
Aye.
Senator Turner. Aye. Senator West.
Aye.
Senator Wheeler. Aye. Chairman Westerfield.
Aye. Bill passes on an 8-0 vote. Senate Bill 101 passed with favorable expression from the committee. Thank you to Senator Carpenter for filing the bill and for the quick vote there, everybody. All right. We're going to take up Senate Bill 40, an act relating to the rights of parents, sponsored by our own member here, Senator Stephen West. Senator, you have the floor.
Thank you, Mr. Chairman, members of the committee. For the new members of this committee, Senate Bill 40, what you have before you is the same bill that we passed out of this committee last year, and a version of this bill, if it passes today, it'll be 3 years in a row that this is passed out of this committee. So this is definitely not a case of first impression for this committee. To some, there's many lawyers on this committee, so I can make this statement as simply as possible as I can state. All this bill does is mandate that the state of Kentucky, when passing legislation or the judiciary interpreting legislation as it pertains to parents' rights, the judiciary must apply strict level scrutiny. So in First Amendment analysis, you've got low level, mid level, and strict scrutiny. And in strict scrutiny mandates that there must be a compelling state interest at hand, and that any legislation must be narrowly tailored to meet that compelling state interest. The reason for this is it has been long understood in this state and across the United States that parental rights were to be held to this standard, and they were highly protected, coveted, and really another level of governance. You had the federal government, you had the state government, but the ultimate government, the ultimate local government was the family and parents. And that parents had clearly have a compelling interest in the care, custody, and control of their children. And so that was not only known in early colonial times, but at English common law. And when you had the English common law that was here, we have what, at that time, at the founding of the country, we had reception statutes. So Kentucky, when it was founded, basically through reception statute adopted the English common law. And so, and this has long been held in the main Supreme Court case is the Troxel case that set this precedent. So the reason for this bill, another reason for this bill, is that we see across the country attempts for the state and others to delve into the area of parental rights, and courts to start applying a lower level standard, a lower level level of scrutiny. So, although I don't see a lot of problems in Kentucky right now, there are a few problems, not a lot. This is really a preemptive attempt to stop things that may be coming along. Senator Wheeler's tired of me talking.
Don't mean, and I don't believe they meant to cut you off either. Maybe they did mean to cut you off, Senator.
That's perfectly fine.
Yeah, but we've got a motion in a second. I'm not aware of. Thank you, Senator Berg's got a question, so I'm going to get to her in just a second. But I don't think there's anyone in the room who wishes to speak on the bill, and I don't think there's anyone remotely that has signaled a desire to speak on the bill. So, Senator Berg, go ahead.
Thank you, Chairman, and thank you, sir. My basic question, and we had a brief discussion ahead of time, so you understand, I think, that I'm coming from, the other side where I've had personal family experiences where a child needed to be removed from a home, desperately needed to be removed from a home, and 5 years it took. So I'm reading like Section 7, or I guess Section 2, Article 7, when a parent's fundamental rights protected by this section are violated, a parent may assert that violation as a claim or defense in a judicial proceeding and may obtain appropriate relief against the governmental entity. And my concern, has to do with Child Protective Services. And how are the individual people who are sent out to a home to make a determination as to whether or not a child is in a safe environment, is this going to have a chilling effect on their ability to do what they think needs to be done? Given, you got to understand from my perspective, frequently what needs to be done hasn't been done, that they're not as protective of some of these children as ideally they would be. So I mean, if I was a social worker and I was sent out to a home and I knew that if I violated this parent's rights, they had judicial relief against me, and I'm already on the edge, I already don't know what to do with this case. How is this going to impact those decisions? That's my question.
It's my opinion that this bill does not impact at all our current statutes as they pertain to child abuse and neglect. Simply stated, if you have a child abuse and neglect law, there's clearly a compelling state interest to prevent child abuse and neglect. So you meet that standard, and whatever law you put in place must be narrowly tailored to meet that interest. So in my opinion, I don't know of any of our current laws would go against. Really, in my opinion, the strict scrutiny standards should apply currently to those laws.
I think it
So
does.
I don't think there will be any effect whatsoever on our existing child abuse and neglect laws. I think the problems you're referencing are probably a breakdown of our current system, and really have nothing to do with it. And I'd be behind you 100% to the effect that maybe we need to tighten some of those down a little bit. So it's my opinion that this bill would not affect those whatsoever.
Senator Carroll.
Thank you, Mr. Chairman. And Senator West, I appreciate you bringing the bill. I know we've had several discussions on this before, and I agree with you that increasingly state entities are going too far in making decisions for our kids. And the concern that I've had with this bill, it has been the same all along. And I can remember as a police officer, and I know teachers, throughout my life have done this, and I know teachers that continue to do this. But, sometimes we have kids that come from families where there is no parental guidance, and there is no support there. And, for me, as a young child, if people within my community had not stepped in and provided me with the guidance that I needed, I don't know what direction I would have taken. And, I have done that as an officer, and I know teachers that do that all the time. And I guess my concern is if you have a parent who is not involved in the child's life, is not providing any guidance, and someone steps in to try to be that mentor, to be that parental figure in that child's life. And then if you have a parent who is maybe prone to file civil suit, it puts those people in a predicament that it's kind of a no-win situation. You want to do what's best for the kid, but you put yourself at risk of civil liability. Is there anything in this bill that has changed that would cover situations like that?
Senator Berg brought up the fact at the end of the bill there's some civil penalty possibilities, civil action possibilities. As a very basic baseline, no matter what we think about parents, they do have a certain level of constitutional rights, and that's, I'll admit, I mean, it's a tightrope. I mean, I know where you're coming from. As it stands now, I don't think this bill changes the status quo too much as it pertains to an outside third party coming in and stepping in as a mentor and trying to do something for the kid. They can get into trouble now if they go too far in infringing upon the rights of parents, right? I mean, and so that line varies from case to case, and it's a tricky situation. But I totally understand where you're coming from. This bill would be a lot easier if all parents were good parents, but you can't let the pendulum swing the other way either. I mean, we've got there's a balance in the middle, and my bill seeks to find that balance, proper balance. So
I wish, may I continue just quickly?
If you've got a question, yes, sir.
Yeah, I just wish that there was a language that covered that specifically. We have already gotten out of practice as a society, the village raising the child. And I think this will further that and make people less likely to get involved. And, these are the kids that are high risk that community needs to be involved. And so I haven't been able to support this bill before. And because of that, I know I don't have the vote in this committee, but I can't support it moving forward. I think we're gonna push those who would tend to help our kids away from helping our kids, and I don't think that's a good thing. Though I do understand the protections that you're wanting to put in place, I just wish we could separate the two and provide some protections to those folks who truly have an intent to help kids. Mr. Chairman, thank you for your indulgence.
Senator Stivers.
Thank you, Mr. Chairman. Senator West, I'd like to kind of get two extremes on this, and correct me if I'm wrong. Troxel versus Troxel was out of the state of Washington that went up to the United States Supreme Court. Am I correct? And I think that was it, and its progeny have created a lot of case law in many states. But the fact situation on that, if I'm not badly mistaken, at one time I did do a little domestic law, was that the parents, being the Troxels, were going to move from Washington to maybe like Colorado or New Mexico, and not certain about the states. The grandparents who helped do some of the daycare and child care for some working parents moved to litigate with, and they were also Troxels, therefore this wasn't a divorce case. This was an abuse, dependency, and neglect case. But the grandparents wanted to assert a right of having a custodial relationship with their grandchildren. I think that was the fact situation. Am I correct? So that's pretty clear, and that's where the Supreme Court came down with this standard that, this wasn't an abuse, dependency, and neglect. Now you've got to go to the far side, and you're wanting to make sure in those situations, this bill makes it clear that the biological custodial parents have a superior right to anybody else unless they do something to raise other individuals, which may be the state, to the level of a in loco parentis or parental caregiver. But those are the standards, and I think that's where people get in fear of what may happen to a social services representative, and it doesn't just need to be a social worker, if they get a report of abuse, dependency, and neglect, and what the standard would be there in our state removal statutes. Now, that's what you're trying to differentiate in. Am I fair on that?
Yeah, and it's to Senator Carroll's point. I mean, his scenario that he brought up. This is just talking about the interpretation of laws. This is the judicial standard of review. So this bill doesn't say that people can't get involved with kids who aren't their own, that grandparents can't be involved, fictive kin situations. All it says is if you're going to pass a law that pertains to those issues, you've got to have a compelling state interest, and it must, whatever law that is, must be narrowly tailored to meet those objectives. And so it's, like I said, for hundreds and hundreds of years, it has been understood that parents have a right in these areas. In this country, since the Troxel case and before, it's been understood by the courts that strict scrutiny is the proper standard of review. The only reason for this bill is that some courts, federal, state, and others, are straying from that strict scrutiny standard. And they're creating gray areas in the law where, in your fact pattern, maybe that grandparent's custodial right all of a sudden trumps the parent's custodial right in some situations. And so that there's a pattern, there's a fact pattern where that may be okay for the grandparents' rights to trump the parents' rights, but it's got to flow through a process and it's got to meet that level of review. So,
any other questions? Seeing none, we've got a motion and a second on the bill. Mr. Secretary, please call the roll.
Senator Berg.
Explain my vote, please.
Yes, ma'am.
Thank you. I am going to vote no. And I understand what you're trying to do here. And I appreciate what you're trying to do here. Because I do think that parents' rights do trump those of other people that are involved in a child's life. And that the parents do have both the right and the responsibility. I also think, particularly in this state at this time, when we are dealing with, the crisis of addiction, and have so many children in states that need to be improved, in not states like Kentucky, but in a position that need to be improved, I think this could have a chilling effect, and I'm worried about it. And I also honestly believe that these rights of the parents are already encoded in law. I believe they exist already, and to restate them is not necessary. So thank you. I appreciate what you're trying to do so much, but I am going to vote no. Thank you.
Senator Carroll. Senator Kerr. Senator Neal. Senator Schickel. Senator Schroeder. President Stivers. Senator Turner.
Can I explain? I'm going to vote aye, Mr. Chairman. I'd like to explain my vote.
Yes, sir.
I really appreciate this being brought forward. We always talk about parents, and as a practitioner who got a case real early where the government was terminating parental rights, then they were poor, and that's what happens all the time. But we judge this strictly on what we look at as parents. Society needs to know that when you do terminate parental rights, and all of us need to look at this recent Supreme Court case, it just came down in the new summary that says you don't even have to terminate parental rights anymore to adopt a child. I mean, there's a scathing dissent in it, and I think it's an egregious act by our Supreme Court. You don't even have to terminate parental rights. When you terminate parental rights of a child, it's forever. It's a stranger to its own natural parents. And this is the first bill that I've seen that steps up to the plate and really says, government, you're going to protect those children's interests. They have a right to be the child of that parent unless we take a great deal of pain to help those parents become the parents we as a society need to make that standard. And we're judging them on a standard. And most of the time, my practice has been, and you can ask all the larger practice in the poor areas, it's the poor people that don't meet that standard of care that government expects. Social services have changed their standard where before they could just substantiate. Some social workers say, well, I substantiate this act, and that's a basis then for taking children away from a parent. This will put the test on the government now. They have changed it somewhat. If you practice this every day, you see the government abuse, and I saw it from my second year of practicing law. And I appreciate this bill. I really commend you, and I hope and pray that this whole body passes it for the benefit of the children that's going to get punished by the government by not becoming a child's parent, the parent of a child and a child of a parent association, because the standard here will increase to where they can't do that without just taking those rights away. Thank you, Mr. Chairman.
Senator West. Senator Wheeler. Chairman Westerfield.
Aye. I believe that puts us at 7-1. Bill passes with favorable expression. Thank you, Senator, for bringing the bill yet again to the committee. And it'll be on the floor. If the committee will give me just a moment, to check with the sponsor of Senate Bill 31. We will not be taking Senate Bill 31 up for a vote, but we may hear it for information only. Give me just a second.
We ain't gonna vote on it, I don't think.
Thanks, everybody, for your patience. I want to make sure we can proceed. We are going to hear Senate Bill 31 for information only, so there will not be a vote. I will not call for the vote or ask for motions or seconds or anything like that. Members, you were distributed a proposed Senate Substitute 2, which will hopefully be before the committee for a vote at some future date. And I believe Senator Storm is going to talk about that based on a lot of the meetings he's had with a number of folks, calls, meetings, and so forth. So with that, knowing that Senate Bill 31 is before us for discussion and information only, Senator Storm, you have the floor.
Thank you, Mr. Chairman, committee members. My name is Brandon Storm. I'm Senator of the 21st District, and with me this morning is Shelley Hampton with CAECO, and we'd just like to give an overview of Senate Bill 31. I became interested in this issue because we have a lot of individuals in Kentucky that understand that we have a Kentucky constitutional section, Section 11, that talks about a speedy trial right, and the Sixth Amendment of the United States Constitution also talks about a speedy trial right. The issue that's developing is a lot of individuals are being detained in local facilities, costing taxpayers a lot of money, and we want to make sure judges are having input. We want to make sure prosecutors are having input into some of these issues. So we've tried to work through a committee sub to take in these considerations. The couple things I want to point out in this bill is this is a conservative bill. It's about liberty. It's about the fact that we have a constitutional right to a speedy trial in both the United States Constitution as well as in the Kentucky Constitution. This bill pertains only to those individuals that are unconvicted and presumed innocent but are unable to make a cash bond. It also deals with issues where we have Kentucky State Police Crime Lab who can't test forensic information or evidence, DNA evidence, so there's exclusions there that we've worked with different organizations about. Individuals who have competency issues, we've tried to address those issues where that's going to be excluded. We've talked about situations where judges have discretion. Judges have the right to order various different kinds of public safety protections, go through the analysis. The only requirement is that they impose conditions that are the least restrictive. It does preserve judicial discretion. And again, we've made a lot of different concessions trying to talk with all the different stakeholders. We've heard from victims of crimes. We've tried to account for their concerns. We've taken consideration from the different organizations that have made appointments with me. I've done Zoom meetings. I've done in-person meetings. So we've tried to do a lot of things to try to make sure that we have a good bill and that it's a bill that's a compromise bill. So, again, there is a committee sub, a couple of different things. Defendants can also waive their right to a speedy trial. We have that clause in there. We have the opportunity for prosecutors and defense attorneys to talk with one another and go before the court and explain to the court, you know, we have a good cause situation that's arisen, and we'd like to continue this matter for good cause. So there's various different things we try to put in here to make sure that we have a good public policy bill going forward. So Ms. Hampton may have some comments as well.
Thank you. Shelley Hampton, Director of Government Affairs for the Kentucky Association of Counties. Thank you for letting us come and speak to the merits of the bill. Of course, jail costs have for decades been an issue for county governments. I always say we're kind of at the end of the slide, just catching what comes down to us. We have zero control over who comes into our facilities, how long they will stay there, what their health issues might be, mental or physical. And so for us, this has been a long time coming. I appreciate the work from Senator Storm again this session to file this bill, to sit down with any stakeholder that will come and talk with him on the issue of this bill. We certainly support the effort and appreciate this chamber's efforts through several different bills to address the issues that counties have brought to you all over the last several years concerning not only the cost, but the length of time that folks stay. The longer they're in there, the more they're away from their support system, away from their families, away from their jobs. And we support the efforts that are being made here, and we hope to continue to work on the bill for any other issues that someone wants to bring to us on it. But we feel like it's a good piece of legislation, and again, it just continues to chip away at the issues that we have brought to the legislature for several decades. So thank you.
Thank you, Ms. Hampton. I appreciate it. Senator Storm, you have anything further?
I did want to, I'm not sure if I mentioned this, but this bill does not pertain to capital offenses. I think there's been a lot of individuals who felt like this bill somehow was going to pertain to capital offenses. It does not. Capital offenses, there's a Kentucky constitutional structure for capital offenses, so this doesn't deal with that. And again, we've got time frames in here: 90 days for misdemeanors, 180 days for felonies, and then those can also be extended for exceptions we've carved out in the bill.
All right, I know I've got a couple of questions, and members, please hold those real quick. I'm going to ask if Courtney Baxter, the Oldham County Commonwealth's attorney there, who I think is on the line with us remotely, I wanted to give her an opportunity to speak, and Judge Summey, if she wanted to speak, I know she's on the line too. Courtney, Ms. Baxter, go ahead. You've got the floor.
All right. Thank you, Mr. Chairman and members of the committee, for the opportunity to speak to you today regarding proposed Senate Bill 31. I am Courtney Baxter, and I'm the Commonwealth Attorney for the 12th Judicial Circuit, which includes Henry, Oldham, and Trimble counties. I've been the Commonwealth's attorney since 2013, and prior to that, I was an assistant beginning in 2005. Since becoming the Commonwealth's attorney, the number of indictments have continued to rise. In my jurisdiction, just like many others, they have nearly doubled, while the resources available to the court system, the lab, law enforcement, prosecutors, and public defenders has remained relatively stagnant, which poses a major obstacle in implementing the proposals contained in SB 31. We had not seen the current version until this morning after Chairman Westerfield forwarded it to me. While some of the concerns have been addressed in the current version, there are still issues with this bill, specifically the requirement to have a hearing in 48 hours upon expiration of the 180-day will put a strain on an already burdened court system, especially in multi-county jurisdictions like mine that only has one circuit judge. This requirement will result in canceling dockets, trials, and other scheduled matters in order to conduct hearings, causing further delay to those already scheduled cases. Now, keep in mind, the defendant's risk assessment level has already been evaluated by pretrial services, which was reviewed by a judge, and the defendant had a right to request a hearing regarding bond. The proposed bill requires an automatic hearing occur on the same issue after 180 days. The 180-day requirement from arraignment to trial in the most serious cases is virtually impossible to meet. Those cases require extensive pretrial prep and motion practice by both prosecutors and defense counsel. Further, the number of witnesses in those cases includes experts, which oftentimes schedules are already booked with other matters, preventing the case from being tried in that time frame. As it stands now, we are scheduling cases for trial in the fall of 2023. Our trial calendar is full for 2022 due to the COVID backlog. The bill provides priority for in-custody defendants, which will result in out-of-custody defendants' cases being pushed to the back of the line, resulting in delay for victims who have a right to a speedy resolution of their cases. There has to be a balancing of equities. A case that is already on the trial calendar with an out-of-custody defendant will have to be rescheduled to meet the requirements of the bill, resulting in justice delayed for those defendants and the victims of their crime. The bill contains a tolling provision regarding delays relating to the lab. However, it expires in 2026. 4 short years is not enough time to remedy the issues with the lab that has been woefully underfunded as long as I've been a prosecutor and before then. Until the lab is fully funded to address these issues, these problems will continue to delay the justice system. The bill does not address the additional delays associated with e-crimes and the time it takes to process that evidence as well. I am certain that many of my colleagues and judges have additional concerns that I have not addressed, and I would urge you to seek feedback before moving forward with this bill. I appreciate the opportunity to address you here today, and I'm happy to answer any questions. Thanks again.
Thank you, Ms. Baxter. I want to thank you and thank your team and thank the other prosecutors who've reached out to a lot of the members of the committee, to Senator Storm, and the work you all do every day. I appreciate it. And I appreciate the feedback, and I'm glad that court for you this morning was switched to virtual so that you could participate in the hearing today. I understand that you had a little change up there, so I'm glad it worked out. Again, I've gotten a couple more questions here. I'm going to wait and let Judge Summey speak if she'd like to speak. I see her there. Judge, you're welcome to have the floor now if you'd like.
Thank you so much, Senator. This is Judge Patricia Summey. I'm a Kenton Circuit Judge. I'm also the Chief Circuit Judge for that circuit, as well as President of the Circuit Judges Association with 150 members. And while I speak for them generally, I don't speak for any of them particularly, and it's my understanding they have reached out. I want to thank you for this opportunity, and I want to thank Senator Storm in particular. He's been very open to conversation, sometimes to his own detriment, and we really appreciate that. He's taken his job very seriously, and we appreciate that as well. I did get a copy of the sub, so I'll go back to just a few high points that I want to talk about in terms of how this affects the judiciary. The first piece is the 180 days. And while every judge, circuit judge especially, I can't speak for the district, but I'm sure they must feel the same way, wish to get defendants to trial as quickly as possible and efficiently as possible. The problem with 180 days deals with the diversity of schedules, not only multi-counties, but in my county, we have my trials now, and because we're pretty current, are being set out 4.5 months out. So that seems like, oh, gee, I'm within the 180 days. The problem is if I have a glitch like you have in the weather today, I get to start all over again and I'm at 180 days. Whether a defendant would consider that good cause or not, I don't know, but it's what happens. I believe also today, and I think the prosecution can speak to this, but we had to take down the grand jury. So you have a lot of 60-day motions that are going to be coming in today because it's grand jury day, and those have not been heard. And we're concerned about that happening. The senator did address that with the 48 hours notice. However, the 48 hours notice speaks to a real due process issue for me as a judge to make sure that all of the individuals who are concerned have the opportunity to be present. That's not only the witnesses for the defendant, but the witnesses for the prosecution, and of course, under the Constitution, to the victims who are involved. So the ripple effect, too, with regard to the 180 days is this. I set about 25, if not more. I'm just minimizing that because I don't keep my calendar. We just keep it moving. If I have 2 serious trials set on the same day, and one of them is anticipating to go to trial but then pleads, I cannot get other counsel prepared because most of them are preparing over the weekend. So now I'm looking at a 180-day issue or forcing them to trial, which if the defendant agrees can be considered good cause. If the defendant does not agree, puts me into a 180-day clear and convincing hearing, which is, as you know, several of you are practitioners, more and more defendants are filing their own motion for speedy trial in the face of what their defense counsel feels they can do. So I'm now at that hearing. The problem with the hearing for me is not having the hearing, of course, but making sure everybody has notice and their opportunity to be heard and to present their case. My next biggest issue with this, because I know everyone, and I have lots of this, bill is chock full of great stuff to talk about. The next issue, of course, deals with the standard. The standard for speedy trial, as we know, was set constitutionally through Supreme Court cases, and that standard is now pulled into a bond issue. So my bond review now, not the speedy trial, although they're tied together, my bond review now is at a clear and convincing standard, which again means that I need testimony. You can't reach clear and convincing just by reading the citation, although some people think that you can. You can't reach clear and convincing by just going back and looking at all the webcams, but you need to have testimony for a judge to feel confident that they are reaching your clear and convincing standard. And that's another issue altogether in terms of that standard. But the clear and convincing standard with regard to bond then goes to, and I appreciate again Senator Storm's putting person or persons in here, so it took away the particularized person. So now I think we can talk about community danger as opposed to danger to a particularized person. We have this particularized imminent physical harm and so particularized imminent physical harm. Well, and just looking at that, I go, okay, we have a lot of cases where we don't have particularized serious of physical harm. I don't know that you'd find it in a trafficking case. I don't know you'd find it in a wanton endangerment case. I don't know that you'd find it in a manufacturing methamphetamine case. And so, and I think that you might not find it in particular. And one of my bigger concerns, and I always leave out some of the verbiage for this particular one, use of an electronic communication system to procure a minor or police officer posing as a danger to one. So you have lots of individuals or serious physical harm, and you have a lot of concerns in how that would meet those statutory requirements for the elements of those particularized cases. Again, I think that has to do with, again, possession of handgun by a convicted felon. What it also takes out of my review is a review I've already made of their criminal history. And it takes out flight risk. And I'm thinking if I have a serious crime and I'm coming up on 180 days, I'm going to try to make sure that the judge only has certain parameters within which they can make. And Senator Storm has been very open in listening to all these things, and I appreciative of it. But statutorily, as this is still written, my fear is that language will not fit some of the needs we have to deal with danger to the community. And so that would feed right into that. I think there was one more thing, if I can look at the bill very quickly, that I was concerned about besides the 48 hours. And I think that says much of what I wanted to get at without holding you all up so much, because this is for purposes of today, a review of the bill itself and discussion. I do want to go back to the issue with regard to the jails. I've talked to my jailer, and we've come down so much since COVID in terms of those individuals that we are making sure that we get moving through the system. So what this boils down to are those individuals who have serious crime, who are back-to-back trials in my jurisdiction. And sometimes they have to be set the same. If I was to set each serious trial on a separate day, I would never be able to have a civil docket because they would all have to be set separately. And then if they're set separately and someone goes down, then I have nothing to feed back into my trial docket. So it becomes an administrative nightmare. I can't say a whole bunch about 13, 14, and 15 that were just added because I haven't had time to really time them. But, I now become the timekeeper. And, I timekeep a lot, but it's another administrative job which puts someone else's, what I think, responsibility on me, which is to make sure that I have everyone moving forward, which again is not a problem. I do it all the time. But to make that 180 days, I've got to move it back 14 days. I've got to move it back to something else. And so it does become a calendaring nightmare. And I think I kind of feel that way about 13, but I've not been able to parse it out yet. So really appreciative of it. Lots more to say about this bill, but I know this is for discussion only, and I'm available for questioning. And I know I talk fast. Sorry about that. Thank you for your time.
Thank you, Judge. I appreciate it. Senator Stivers had a question of you briefly.
Judge, thank you for your comments. I'm a bit confused by something you said. You made a comment that because you had to cancel a grand jury today, you're going to get a lot of 60-day motions. The 60-day motion is where you've been held in custody, no indictment has been returned for 60 days, you can move for a dismissal. Therefore, this legislation wouldn't even impact that situation.
I agree, Senator. I'm sorry. I was just using it as an example. And that example was probably based on my prior understanding before some of the substitutes that this would act sort of like that 60-day motion. So I'm sorry to confuse you, but I do understand the difference, and I apologize.
Well, I'm sorry. I haven't practiced that much, but I think I remember a 60-day motion, and that wouldn't be impacted. I don't want members of the committee to be confused by that.
I appreciate that.
Thank you, Judge. Thank you, President Stivers. All right.
Can I ask a question?
I'll add you to the list there, Senator Turner. Okay. I want to go ahead and get to the questions. Members, again, get to the question. We've got about 12 minutes to go, and that's a hard stop. Senator Wheeler.
Thank you, Mr. Chairman, and thank you, Senator Storm, for this bill. I guess a question I had, and I noticed this on the committee substitute versus the original draft, that I think under subsection 10, where the judge had to identify particularized risk of imminent serious physical harm to a reasonably identifiable person or person other than himself or herself, you have sort of broadened that language, which I think is a good thing. In your opinion, would this bill allow the judge to make a finding that a particular person or person that it posed a risk to the society at large, and therefore they would be able to hold these folks beyond the 180 days in situations where they might pose a serious risk? I think a couple of my circuit judges did contact me and specifically mentioned like a fourth offense DUI, that for somebody that maybe had a third offense pending. Would the judge be able to make a finding that based on the prior behavior that there was clear and convincing evidence that this particular defendant would pose a danger to other motorists on the roadway?
Thank you for the question. Senator Wheeler, basically that was a concession that Judge Sumi had raised with Judge Lay as well as Judge Ward, and I've also spoken with the Commonwealth Attorney's Office about that language, and so that was a compromise that I felt was appropriate to allow these judges discretion, and I think you're exactly right in your analysis. It does allow the court to have that hearing. It does allow the court to make a finding. I think it's important that if we're going to restrain individuals' constitutional rights, that we have judicial findings. So I do agree with your assessment, and that was a compromise language we put into the committee sub for that reason.
Thank you, Senator.
Thank you, Senator Stivers. Have any other questions? I know we had to. All right. Senator West.
Thank you, Mr. Chairman. Got a question for Judge Sumi or Mrs. Baxter, whoever wants to chime in. Clearly, you don't like the 180-day time frame. Is there any time frame that you could agree to or would would think would be a good amount of time?
I honestly think in order to gauge an appropriate amount of time to address these issues, we've got to have the adequate funding for the resources to handle the backlog of cases that we have. And without that, it's hard to get a gauge on how fast we can get these very serious cases prepared and ready for trial. I hope that answers your question.
It does. It does. I'm coming at this. I was ready to vote yes for this today because I've got a constituent of mine who's been in jail for 3 years without trial, and that county's having a limited number of trials. And so you talk about funding. This legislature put a great deal of funding into the crime lab, and thank goodness we're going into pretty good budget years, so there's a lot of asks for additional funding. But having said that, the Constitution doesn't sleep during a time of COVID or during a time of low funding. So, and the burden is on the state to try these people in a speedy manner. So, I appreciate the bill today. I thank the sponsor. That's information only. But just one more thing. I mean, we've been trying to do judicial redistricting for years that would take care of some of these issues, and the AOC has kind of balked on that. And so there's going to come a time where bills like this need to move forward, and people cannot be held indefinitely in our jails. So, thank you to the sponsor. Thank you.
Senator Schickel.
Thank you. And I, too, want to thank the bill sponsor for being so gracious. I know he's put up with a lot for me the last probably month, and so thank you, Senator. First of all, I'm a little disappointed in Keiko because I was talking to the Jailers Association this morning. I thought it's interesting that they're not opposed to this bill, and I always thought that Keiko, had all its associations on board before they took a position on the bill. Could you address that for me?
Right. The jailers, I spoke with their director. They are neutral on the bill. They have folks that are for it, and they have folks that are opposed to it, and so they are neutral on the bill.
So you proceeded without their membership?
Yeah, they're not opposed to it. So
right.
We did.
But it isn't okay. And that's normal procedure if you if you have somebody neutral. Mm-hmm. Okay. The second question I'd like to address to either the Commonwealth Attorney or the judge or both. What are the practical implications on this bill on public safety? And Mr. Chairman, I have a follow-up.
Judge Summey, Ms. Baxter.
I can just tell you what I view from when I'm setting bond and I'm looking at past history to determine whether or not that individual's behavior is going to create a danger to the community. And so if I have someone who's got a trafficking and a controlled substance, first degree, second offense, I've already have someone whose behaviors have seriously impacted the community. And so if this person is then released and they're in on another charge, well, they've already had the charge, then that creates concern. And certainly in some instances when we have bond review and modification request, we look at it to see how serious that is and whether the individual can be released or not. So we have ongoing discussions as we move through the calendar to make sure that people are, and the facts of each case are being addressed. And I ask for more and more information from the Commonwealth Attorney as things move down the line to make sure that I am not holding somebody without enough proof on their part. I don't know whether it reaches the standard of clear and convincing, but we look at it with much scrutiny to make sure someone's not being held. Not just for the cost, but for the safety of the community. And so trafficking controlled substance is an easy one because it's out there all the time. But, there are some more serious things that would cause release. And of course, someone who was using electronic communications for minors is always serious because there's no way once somebody is released, you can control access to electronics.
Very quickly on your follow-up, Senator Schickel.
Thank you, Mr. Chairman. As you stated to me in your lengthy memo, Judge, and I believe the rest of the committee did get copies of it, the right to a speedy trial, of course, well-established law, and it's well-established in Kentucky case law. So for me, the question is not that whether someone deserves a speedy trial. We all know that they do. It's who makes those decisions and how those laws are interpreted. Can you explain to me currently, under current case law, if a defendant invokes the right to a speedy trial, if they ask for a speedy trial, are they able to get one?
If I look at the case and there's something before me and I find out that there is a delay and it's a delay by the prosecution just for delay, and if there are those things that they've not been prompt with looking at their cases, because it's really the prosecutor's obligation to be prepared, yeah, we move forward. And, you know, much of the problems occur, as I think the prosecutors here can tell you, is if we're not getting the testing done, then the defendant is concerned about exculpatory proof on their own part. And so they're not as opposed to it for those reasons. So yeah, if the question is I force people to trial before, the answer is yes, you know, because it's really important that, you know, that someone's constitutional rights to a trial are enforced. So we're not upset or disheartened by this timing, other than the fact that administratively and for many other reasons, including evidentiary reasons, it's very difficult to meet and match.
Senator Turner.
Thank you.
Thank you, Mr. Chairman, and I appreciate the hard work this senator's put into this bill, and I'm going to support it. I have a question for the judge. Could you tell the public and us about how many days per year that you spend on civil practice in your courtroom and how many you would have some criminal practice in your courtroom? Can you give us that? If you can't give it to us today openly in court, could you supply that to the committee so we'll have some understanding and try to use that as a basis for most courts of saying then these constitutional rights of the defendant are getting this many days and the civil rights of the civil people are getting this many days per year. So we will have some understanding and maybe funding and everything else can help.
I can ask my secretary to make sure that you have a copy of my calendar. More than happy to do that. But you know, I have 8 to 9 criminal dockets a month. I have 2 on one week, 1 on the next, 2 on the next. And I do that so I can get to trial on Tuesdays and Wednesdays. The trial priority is always the criminal trials. I have at least 25 set on most days in order to get those to trial. And so I'd be happy to share my calendar with you. Whether I can get you the exact data, I don't know. But if that's helpful, we'll run a copy of it for you.
I would appreciate that for the last year or how many months you could give it to us so we'd have some analysis to make and maybe help the system move forward, because I appreciate everybody that respects the Constitution and pushes to get constitutional rights done. Thank you.
Senator Schroeder.
Thank you, Mr. Chairman.
Last question.
Thank you. My question is actually, Mr. Chair, a procedural question for you more so, maybe for the bill sponsor.
Sure.
But it seems like a lot of people aren't aware of the sub or the changes that the sub makes. So I was wondering, I know we don't want to vote on the underlying bill, but would it make sense to adopt the sub just so it could be posted on the LRC website so when people are reading the bill, then they would actually have the right bill to read?
Let me check with staff. I don't know if just adopting it without reporting the bill would result in it being on the LRC website. I don't know that it would be there. And do you know the answer to that? Yeah, let's just do this. If you've got a question, I don't have a problem with adding it to the committee materials if we can do that on the website. So let's make that request. I think it's a fine request. I'm happy to make that. So we'll put that on the meeting materials on the Judiciary page. We do that during the interim. We put materials up there in advance of the meeting. Happy to do that with the committee sub. I sent it out by reply to one of the Commonwealth's attorneys this morning, and I think their entire listserv was in the reply field, so they all have it. I'm happy to send it to anybody else if you can't find it online, but I think it's a fine request. Did you have anything else about the bill? And thank you, Senator Schroeder. I appreciate that. Senator Storm, I'm going to give you the last word. You've got about no minutes left, so take about a minute and close us up. We're obviously going to come back to the bill, and it's generated a lot of discussion, so please close us out.
I'd just like to end on the fact that Kentucky has a constitutional provision, Section 11, I'd ask everybody to look at, and it talks about a right to a speedy trial. The problem is it goes back to the question that was posed by Senator Schickel. Kentucky's law currently requires a defendant to ask to invoke that right. So if it's a right that we have, the right to go to church, the right to free speech, we shouldn't have to ask to invoke that right. If I want to go to church on Sunday, I should have the right to do it. So I'm asking the committee to consider putting this right that we have in the Constitution as a right that does not have to necessarily be invoked by a motion that then requires a hearing for a judge to preside over to determine whether or not someone's right to a speedy trial should be granted. Thank you.
Seeing nothing else before the committee, we are adjourned. Travel safely, everybody.
Thank you.